others out there later. My name is Harry Weiss. You're attending another in a series of Ballard Spahr's CLE program. I am proud to be the chairman. I'm equally proud to have a wonderful audience and a pretty full house, which is terrific. We try as much as possible to provide cutting-edge legal education, and tonight is no exception. Tonight, you're going to hear all about Act 95, Pennsylvania's new power of attorney laws, presented by my colleague Lindsay Ermey and Benjamin Trays. I'll let them introduce themselves. Their information is also in your materials, I assume. If there are any questions about this or other programs, please come to me. I'll be out here or in the back. And we would also appreciate, as would Lindsay and Ben, your evaluation of tonight's program and any ideas for CLE that you'd like to see us do. Again, thanks for coming. Enjoy the program, and we'll see you afterwards. Lindsay?
Hi, everyone. Good evening. I'm glad to see you all here. Thank you for coming. I'm Lindsay Ermey. This is Ben Trays. We're in the Family Wealth Management Group here at Ballard. We're going to talk a little bit about Act 95, as you know from the title of the program, it's a statute that was enacted July 2nd, 2014. It changes Pennsylvania's power of attorney rules in some pretty substantial ways. Our goals today are to give you an overview of those various changes and some practical approaches to dealing with some of the gray areas. So with that introduction, I'm going to turn it over to Ben, who is going to leap right into why we're here.
As you can see from the first slide, Act 95 was precipitated in part by the Pennsylvania Supreme Court's decision in Vine versus Commonwealth. Prior to that, the Joint State Government Commission had been tasked with reviewing the Uniform Power of Attorney Act in 2007. It issued an advisory report in March 2010, and then in May 2010, the Vine decision hit. If you don't know, Teresa Vine was a state employee, Pennsylvania state employee. She was injured in an accident. 2 days later, she suffered a stroke, and then 4 days after the accident, she managed to execute a power of attorney, naming her husband, Robert, as her agent. She signed by Mark, and nurse witnessed, and the power was notarized. The Vine decision notes that she was suffering from a traumatic brain injury, was intubated, was being treated with sedatives that affected her reasoning and judgment, and was unable to make important life decisions due to aphasia. Shortly after she executed the power of attorney, her husband, Robert, as her agent, met with a retirement counselor from the Pennsylvania State Employees Retirement System. He elected a retirement option that was most beneficial to him, not her. I think he was able to withdraw all her contributions. I think in his eyes, she was probably not going to make it. So after she miraculously recovers, in 2003, about 5 years after the accident, they were going through divorce proceedings, and she learned at that point that she was officially retired and not on disability retirement. So what she did at that point was sue the Pennsylvania SERS program to retroactively adjust her benefits to something that would be a bit more favorable to her and not her ex-husband. SERS relied on the former statute 5608B, which provided any person who acts in good faith reliance on a power of attorney shall incur no liability as a result of acting in accordance with the instructions of the agent. The Supreme Court found that Section 5608 immunity did not apply. It applies only to valid powers of attorney, and SERS was required to adjust Teresa Vine's benefits because the power of attorney was invalid and the agent's instructions were a nullity. I think the court actually said that he was not an agent. So after Vine, I think that people were kind of left in the daze. They didn't know what third-party immunity meant under 5608B. The decision meant that they were not entitled to rely on a power of attorney and might be liable to the principal for improper acts by the agent. But at the same time, under Section 5608A, Civil liability can be imposed on any third party who, without reasonable cause, failed to comply with the instructions of an agent, specifically for any damages resulting from non-compliance with the agent's instructions. Reasonable cause was kind of vague at that point in the statute. The statute provided one example: a good faith report having been made by the third party to the local protective services agency regarding abuse, neglect, exploitation, or abandonment under the Older Adults Protective Services Act. So not very helpful. The only alternative to acceptance of a power was to request and rely on an affidavit from the agent that the power had not been terminated and that any contingencies to effectuate the power have occurred. However, requesting an affidavit would not cure liability if the power of attorney was void after Vine. So Act 95 addressed the Vine problems, the dilemma, by expanding immunity from liability for good faith acceptance of powers of attorney, by providing actions third parties may take to resolve questions about validity of powers of attorney, by establishing standards for determining when a third party is not required to accept a power of attorney, and limiting liability for the wrongful refusal to comply with the instructions of an agent. Section 5608D, as amended by Act 95, now provides that a third party may, without liability, rely upon the power of attorney as if it were genuine, valid, and still in effect, unless the third party has actual knowledge that the power is void, invalid, or terminated, or the purported agent's authority is void, invalid, or terminated, or the agent is exceeding or improperly exercising the agent's authority. The Vine decision also raised questions about signatures, and after Vine, are you going to be required to determine whether or not a signature is valid? Under Section 5608C, a third party who in good faith accepts a power of attorney without actual knowledge that a signature or mark on a power of attorney is not genuine may, without liability, rely on the genuineness of the signature or mark. The presumption of genuineness extends to the signatures of the principal, a person who signs on behalf of the principal, a witness, or a notary. This may be a good time to note also that good faith is now defined in the statute as honesty in fact. So,
and I challenge any of you to tell me what the opposite of honesty in fact is. Is there honesty not in fact? I'm not quite sure what honesty in fact is, frankly, but actual honesty, perhaps.
I've gone too far. And just a note, Section 5608's expanded immunities do not validate forged instruments conveying an interest in real property, make a forged instrument effective to give constructive notice of a conveyance, or limit the liability of insurer, indemnitor, or guarantor of contractual obligations to indemnify or defend a person who accepts or relies on a power of attorney. Another thing Act 95 does is kind of give a checklist of what must occur when you are presented with a power of attorney. Upon an agent handing you a power of attorney, within 7 business days, you either must accept the power or request additional information about the agent, the principal, the power of attorney. And third parties may not require that an additional or different form of power of attorney be executed.
And for your entertainment, I'm going to jump in on Ben's presentation periodically without giving him any warning.
Perfect.
So that can be
helpful. I love it.
So you can watch his surprise on his face. I told him about some of them. In terms of thinking about whether or not a third party can require a special form of power of attorney, the statute says that you can't require it, but it occurred to me that you could, as a practical matter, say, convince someone to sign your power of attorney because there are these waiting periods. So you can ask for information, and you have 7 days. I mean, Ben's going to go over this on the next slide. 7 days to sort of get an opinion of counsel or get an affidavit from the agent. And in a situation where you have a principal who's still competent, like say if you're doing a real estate closing, for example, and the title company wants their form signed, it could be that they could say, well, either we're going to have to get an opinion of counsel, or you could just sign this form, this R form. You could re-execute it. You could use it. It's not pleasant, and I don't know that that's going to happen, but certainly it does seem within the realm of possibility that even though the statute says you may not require it, that it could be something that third parties continue to do for their convenience and mostly for their convenience.
Yeah, I think that would smooth things along, help things out. So under 5608E of the new statute, in that 7-day period, you can ask for certain things. You can ask for an agent certification of facts relating to the principal, the agent, or the power of attorney. You can also ask under what was an existing section, section 5606, of proof of continuance of the power of attorney. For powers of attorney that I have never seen one that is completely or partially in a foreign language, you can ask for an English translation of the power, or an opinion of counsel relating to whether the agent is acting within the scope of authority granted by the power of attorney, as long as you, in writing, state your reasons for the request.
Ben and I had a lively debate about this earlier, which we'll try to recreate for you here. One thing we were thinking about is, there is this idea that a bank is immune from liability for accepting a power of attorney that's been executed properly and they have no actual knowledge of any defect in it. But then you have this idea that you can take extra steps to confirm the validity. And one question that was on my mind is sort of, is a bank better off taking those steps? Must they take those steps? Let's say if there's a signature by Mark and the principal has been a customer of the bank for years and years and they've always signed their name, and now there's a signature by Mark. And we were sort of kicking around, like, should the bank then inquire? Are they opening themselves up to liability by not inquiring? This is the part where the debate ensues.
Right. I mean, I think that there you have actual knowledge that it's not the signature. So if it were a new client or a new customer, 5608C would say that you could rely on the signature. But if you have actual knowledge that that's not the signature, I think that there's definitely a gray area of question. You should probably seek some kind of certification asking why. What are the, if he is right-handed but had an arm injury, that might be helpful. Something saying that he's competent otherwise, but for an arm injury, I think he'd probably be okay.
Right. So in Vine, pretending that the statute was already in effect, the state employees retirement system might have, say, requested, a confirmation that the principal was oriented to time and place, or that she was responsive and not sedated, or any number of medical inquiries. That also sort of leaves open the idea that, how is a bank to know what a medical condition is, or whether or not the principal was. I mean, at some point they have to rely on someone, and I think that under a certification under penalty of perjury, you should be able to rely on that. So.
Yeah, absolutely. Another thing Act 95 did was provide certain situations in which a third party is not required to accept the power of attorney. There's, I think, 7 or 8 of these, and I will just read through them as quickly as possible. The first is if the person is not otherwise required to engage in a transaction with the principal under the same circumstances. I think that if there's an ongoing customer relationship or something like that, you'd probably be forced to deal with the agent under the power of attorney. But if it's a new client coming to a law firm if the agent's coming to a law firm on behalf of the principal, you could probably turn them away if there's some question about the power of attorney.
Or engaging a real estate agent.
Yeah, exactly.
That was your example that I stole.
The next is the power of attorney has not been properly executed, and this would be, Lindsay's going to cover new execution requirements, but if some of those are not met, as you may know, Pennsylvania requires agents to acknowledge their duties, and if that's not done, then there's no reason to accept it, and you're not required to. Engaging in a transaction that would be inconsistent with any law or regulation, a request for certification, affidavit, translation, or opinion, as previously noted. If the agent refuses to give any of those, then the third party is not required to accept. The third party in good faith believes that the power is not valid or the agent does not have the authority to perform the act requested, regardless of whether a certification, affidavit, translation, or opinion of counsel is provided. And I think this is when we were talking about if the third party is the bank where the principal's sole bank account is, and they give annual exclusion gifts in January, and then in December, the agent who only has the power to make annual exclusion gifts is attempting to give more gifts, I think that would be exceeding the agent's authority in that situation.
And so even if the agent got a certification that, you know, I don't know, it has to be under penalty of perjury, so it seems unlikely that the agent would certify that previous gifts were not made. But even if they produced that certification somehow, the bank would have knowledge otherwise and therefore could, in good faith, decline to accept the instructions from the agent.
And finally, the third party has actual knowledge that the report has been made to a local protective services agency of suspected physical or financial abuse, neglect, exploitation, or abandonment of the principal. And finally, Section 5608.1c now limits third-party liability for refusal to accept a power of attorney to pecuniary harm of the economic interests of the principal proximately caused by the person's refusal to comply with the instructions of the agent designated in the power of attorney. As noted earlier in the previous act, civil liability, third parties were subject to civil liability for any damages resulting from noncompliance with the agent's instructions. I think there's a vast difference now between potential damages here versus the old law here. It's much more narrow, much limited.
Well, so now it's my turn and Ben's turn to interject at random intervals just to keep me on my toes. The second sort of group of things that Act 95 addresses is it attempts to prevent abuse and misuse of powers of attorney. So the ways it does that are by restricting the ability of an individual to sign on behalf of a principal. It adds more stringent execution formalities. It expands the forms of notice to be given to the principal and as an acknowledgement of the agent. And it requires that certain powers that are granted to an agent be given by a specific grant in the power of attorney instead of just the usual, my agent may do all the things that I could do myself. So, Ben, can I enlist you to press that for me? Okay. So first, this idea of being able to execute on behalf of the principal, executing a power on behalf of a principal.
Doing it.
It's not moving. All right, well, I will continue on, and you all have them in front of you, so I apologize, and Ben, you keep pressing that. Let me know when it happens. So under prior Pennsylvania law, a power of attorney could be executed on behalf of another at the direction of the principal. That really didn't give a whole lot of description. Now, the revised Section 5601B says that execution by another individual may be made if the principal is unable to sign, but specifically directs another individual to sign the power of attorney. And you tell me if you think that's an improvement. I'm not so sure, because it says unable to sign, but it doesn't really talk about, and nowhere in the comments does it talk about what unable to sign means, but we can delve a little more deeply and see if we can figure it out. So the Uniform Power of Attorney Act has a requirement that it be done at the direction of the principal in the principal's conscious presence. And the comments to the Uniform Act say that that should be within the sight or hearing of the principal. And so really that lends itself to just a physical disability, physically being unable to pick up the pen and sign the paper. Here, there's no such requirement, and it kind of leaves that open under Pennsylvania law. And so I was thinking to myself, well, does that mean that you can just, you know, you're off in California on a business trip and your spouse decides that they're going to sign a power of attorney for you? And I don't think it goes that far. I think that, you know, there's another requirement that we'll talk about. Well, not a requirement. It's something you're permitted to do. You're permitted to use a photocopy of a power of attorney in place of an original. And so in this day and age of email and fax, it seems like if you can sign it, you could fax it, you could email it, you could use a copy, and so what's the point of having someone sign on your behalf? I suppose if you're stranded in the Sahara Desert and your spouse absolutely must sell your house that day, maybe. But I think it does leave a bit of a gray area, but I personally am leaning towards, you know, physical handicap, physically unable to sign. Okay. We fix this? I
think so.
Yes. Okay. The second way in which the new law tries to prevent the misuse and abuse of powers of attorney are by providing new execution formalities. Under prior law, it was just, you know, 2 adult witnesses, even where you just had a signature by Mark or on behalf of someone other, you know, on behalf of the principal. So an individual was signing, as well as just your garden variety power of attorney where the principal actually is signing. Now, we have under 5601B, the principal has to sign in front of 2 witnesses and a notary public or another individual authorized by law to take acknowledgments, which a bunch of the people in this room know that that is a member of the Supreme Court of Commonwealth of Pennsylvania. So, Benji's laughing at me, and maybe that's a good sign. The witnesses also cannot be the person signing on behalf of the principal, an agent who's being appointed, the notary, which that's pretty basic, or the person authorized to take acknowledgments. So that kind of creates a little technical problem in a lot of, at least in my practice, which is that elsewhere in the Pennsylvania statutes, a member of the bar of the Supreme Court is allowed to take acknowledgments, but it says that they have to be a subscribing witness to the document. So usually you would, you know, if you're serving as the person taking acknowledgments, you sign as a witness, and then there's a special block saying, I saw them sign, and I'm going to go get my signature notarized. I think the way off this proverbial flypaper is to have 3 witnesses, to have 2 witnesses who fit the requirements of 5601B, and then have the attorney serving as notary serve as a 3rd witness. So you have this extra witness, and nobody can really fault you for going above and beyond, but you're still meeting the requirements of, it's 57 PA Consolidated Statutes 316 or something like that. So you're still meeting those requirements, but also meeting the requirements of this new statute. So I note that these take effect on January 1st, 2015. So everybody should get their forms ready. Another way in which the legislature tried to protect principals against abuse and misuse of powers of attorney is to give them more or different notice. The current law requires that principals receive notice. If you've seen it, it's in all caps on the first page of a power of attorney, and if the notice isn't there now and in the future, and future law after January 1st, the agent has the burden of showing that the exercise of authority is proper. Again, not much guidance for how you might show that, but there you have it. So Act 95 revises the notice to the principal on that first page, and the first thing it does is it gets rid of the requirement that tells the principal that your agent must keep your funds separate from his own funds. This is because elsewhere in the Pennsylvania statute, it's basically an acknowledgement of what already was going on, which is that spouses appoint each other as agents, spouses hold their assets jointly. just because one of them becomes incapacitated does not necessarily mean that they're going to sever all their joint accounts. And so there's no hard and fast requirement anymore that in certain situations that agents hold their assets separately from the principal. And that is typically where the agent is a spouse or where the assets were held jointly prior to the execution of the power. So that's item number one. Item number two is that there's a statement that the agent must act in accordance with the reasonable expectations of the principal to the extent actually known and otherwise in the best interest of the principal and only within the scope of authority granted in the power of attorney. So it's saying, hey, principal, your agent has to act in your best interest and they've got to act within your reasonable expectations. And perhaps that triggers a conversation between principal and agent about what the reasonable expectations are. I think that would be your best case scenario. I am not entirely sure that it really does a whole lot other than change the words that you have to put on your notice. But
Lindsay, will you advise clients that they should do that?
I don't see how communication between principal and agent could be a bad thing about, here's what I expect and let's have an open conversation about it. As a matter of practicality, we certainly have clients all along the range of willingness to talk about any of their estate planning documents. Some are really open and happy to talk, and others are, they don't even want their agents to know that they've executed a power of attorney, and they ask us to hold it in our vault unless and until it's needed. Sort of runs the range. But yes, I think, telling your client that this is a really powerful document and that your agent is supposed to act in accordance with your reasonable expectations, but maybe you better talk to them about what that is. I think that's good advice, I think. Finally, and this is sort of tied into what we were just discussing, which is that there's a statement warning the principal about the kinds of broad powers that can be granted, specifically as a specific grant, which are the powers to give away your property during the principal's property during life, and to change the testamentary disposition, meaning that they can change a revocable trust, they can change beneficiary designations, and we'll get to this later, but that's only if the power says that specifically. So if I'm not boring you all to death, I am going to go on to Acknowledgement of Agent. This is the flip of what happened in the notice to the principal, which is that the agent used to be required to acknowledge that the agent will exercise the powers for the benefit of the principal, will keep their assets separate, will exercise reasonable caution and prudence, and keep full and accurate records. Now they have to, and this will seem mighty familiar, acknowledge that they will act in accordance with the principal's reasonable expectations to the extent actually known and act in the principal's best interest, and it's exactly the same language. So again, you have the agent acknowledging it on paper, they're signing it in front of a notary, they can't exercise the powers under the power of attorney until they do that, but I don't know how much farther that gets you where somebody is intent on fraud or abuse of a power of attorney, but for what it's worth, that's what the Pennsylvania legislature thought would protect principals better. And then we have, and I will not bore you with these, exemptions from execution formalities. Essentially, all of these formalities are required except, and the first 6 or 7 there have to do with business transactions. Powers of attorney that are granted for use in a limited partnership or something like that. And the last one is powers of attorney that are applicable only to healthcare, which have an entire other chapter under the PES code and have their own execution requirements. So with that, I'm going to turn it over to Ben to sort of talk about the kitchen sink of the statute, which is the ways in which it's conforming to the Uniform Power of Attorney Act.
Right. So the Uniform Power of Attorney Act has been adopted now in 16 states, and I learned today that legislation is pending in 3 states. So maybe soon it'll be 19. Act 95 conforms Pennsylvania law to the Uniform Power of Attorney Act by revising provisions relating to duties of agents, actions that require a specific grant of authority, authority of agents to make gifts, use of copies of powers of attorney, powers of agents to engage in securities transactions, powers of agents, powers of agents to engage in insurance and annuity transactions, and validity of powers of attorney subject to laws of other jurisdictions. With respect to duties of agents, prior Pennsylvania law provided that an agent acting under a power of attorney has a fiduciary relationship with the principal, which, in the absence of a specific contrary provision, required the agent to exercise powers for the benefit of the principal, keep the agent's and principal's assets separate, exercise reasonable caution and prudence, and keep a full record of all actions, receipts, and disbursements on behalf of the principal. That last one we're going to come around to again later on. Act 95 now establishes mandatory non-waivable duties, but nothing very specific. Agents must act in accordance with the principal's reasonable expectations to the extent actually known by the agent and otherwise in the principal's best interests, in good faith, and only within the scope of authority granted in the power of attorney.
That sound familiar to anyone? I just read it twice. I'm so sorry. That's 3 times. Go ahead.
Notably missing from the mandatory duties is a duty to disclose transaction or a duty to, get the wording right, keep a full record of all actions, receipts, and disbursements on behalf of the principal. Act 95% provides a general rule that agents are not required to disclose transactions conducted on behalf of the principal. There are some exceptions. An agent may be ordered by a court to account for such transactions. There's also Section 5610, which was in the previous act or previous law and has not been changed, which states that a court may order an agent to file an account at any time, and the agent may file his own account at any time. Additionally, certain individuals and entities may request an accounting, including the principal, a guardian, a conservator, another fiduciary acting for the principal, a governmental agency having authority to protect the welfare of the principal, or the personal representative or successor in interest of the principal's estate. So the way that works, though, is if somebody requests or a court orders, the agent has 30 days to comply with the request to file, or must state why more time is needed to comply with the request, and that buys them another 30 days. Next, we have waivable duties of an agent. These are found in Section 5601.3b. They may be modified or waived in a power of attorney. The first is act loyally for the principal's benefit. And that's my favorite waivable one, that you may act disloyally for the principal's benefit.
Yeah, I mean, I think it's more in the fiduciary sense of having a duty of loyalty, that you might want to be able to waive the duty to act with the duty of loyalty to the principal. The principal might, say if your spouse or your child perhaps is your agent under your power of attorney, a duty of loyalty is to, act only in the interest of the principal and to not enter into any transactions where you have a conflict of interest. You might want your child to be able to, say, buy your beach house or sell your business in which they are a partner, or any number of things. And so you might want to waive that, although on the other hand, that's meant as a protection for the principal. It's a baseline protection that somebody shouldn't be on the opposite end of a transaction where, it's a zero-sum game. If they profit, you lose. But at the same time, these are family matters, and so sort of the way you might counsel your client in that is to sort of parse out the situations where it might be applicable and figure out what's most important to them.
Right, and kind of piggybacking on that one is act not to create a conflict of interest that impairs the agent's ability to act impartially, in the principal's best interest. Kind of similar conflict of interest issues there. Next is keep the agent's funds separate from the principal's, and as Lindsay noted, there are 2 exceptions. Funds are not kept separate as of the date of execution of the power. The agent is the spouse of the principal, and again, that kind of just reflects the realities of what really happens. Next is keep a record of all receipts, disbursements, and transactions. That's the waivable duty. In the previous law, it was a mandatory requirement.
Although I can't for my life figure out why you would waive that one, or at least why the agent would be willing to operate without keeping records, because they could be called to account at any time, and if they don't keep records, that's going to be a bear of an accounting.
Right, yeah. Act with care, competence, and diligence, ordinarily exercised by agents in similar circumstances. This is another great one where you can lower the bar for some reason.
We're going to be taking questions and answers later, and one question I posed to you is if you can come up with a situation in which you might do this. The only one I could come up with was that maybe if a principal has, say, 2 children who don't get along, and they're appointing good child as agent, and nefarious child is litigious and wants to, and will use the courts to try to get more money. Maybe by lowering the standard to, say, a gross negligence standard, you could try to save good child from litigation, that they wouldn't really have a cause of action. We read a whole bunch of articles about this and couldn't really find anything. So that's a challenge for the question and answer session. Okay, yeah. Fair enough. Yeah.
Did everybody hear that? You're expanding the pool of people who are willing to be agents. That makes sense. I like it. Next, we have cooperate with a person who has authority to make healthcare decisions for the principal to carry out the principal's reasonable expectations to the extent actually known and in the principal's best interest. And finally, attempt to preserve the principal's estate plan to the extent actually known by the agent if doing so is in the principal's best interest based on all relevant factors. The statute lists 4 factors, which are the value and nature of property of the principal, foreseeable obligations and maintenance needs of the principal, minimization of taxes, all taxes, I think it lists income, GST, gift, estate, and benefit eligibility for certain programs, excuse me. And we were talking about this earlier. So what you actually need to do kind of estate planning work, we think that you would actually need to waive this power to give your agent the broadest power to engage in estate planning and give them a specific grant of authority to amend a revocable trust if you have one, or create one if you don't, and to change beneficiary designations on certain policies.
I mean, this has always been kind of a tough area to counsel clients in, because you have, on one hand, you want to grant your agent the broadest possible power because you don't know if you're going to become incapacitated, and things change. You know, I wrote down here Medicaid planning. That's just one of many things that might change in your estate plan, and if your agent is locked into what you had as your estate plan right before you became incapacitated, then they can't respond to changing circumstances. On the other hand, I just got a call from a colleague of mine today who said that we're representing some siblings, one of whom is the agent, and the agent has been absconding with funds, also known as making gifts to himself. That is, it could be construed as estate planning, and if you, it's certainly within certain limitations. Your agent can't be making gifts to him or herself all the time, but at the same time, if you gave your agent broad latitude to do estate planning and you wanted them to be able to take all the actions necessary to, say, produce the best tax result, you might give them this broad power and let them make beneficiary designations, but it's again, a matter of trust. It's a matter of what's more important to you, not paying as much tax or making sure that everything definitely goes into trust for your kids. So that's sort of, that was some of my analysis of it.
Oh, that's good. Act 95 also limits liability of agents. There's really no easy way to do this except to read these to you. An agent who acts in good faith is not liable to a beneficiary of the principal's estate for failure to preserve the principal's estate plan. An agent who acts with care, competence, and diligence for the best interest of the principal is not liable solely because the agent also benefits from the agent's acts or has interests that conflict with those of the principal. Absent a breach of duty to the principal, an agent is not liable if the value of the principal's property declines. If an agent is selected by the principal because of special skills or expertise possessed by the agent, the special skills or expertise must be considered in determining whether the agent has acted with care, competence, and diligence under the circumstances. And if an agent delegates authority to another person, the agent is not liable for an act, error of judgment, or default of that person if the agent exercises care, competence, and diligence in selecting and monitoring the person. We were talking about the fact that these are kind of the flip of the duties and line up nicely with those. I also wanted to note, given many agents are selected because they do have special skills, and the top one on the current slide shows that those special skills will be considered in determining liability.
Unless you've waived care, competence, and diligence, in which case, no liability.
Have at it.
So the next item in the kitchen sink are the specific grants of authority, and we've been talking a little bit about these all along. This is another way that Act 95 also attempts to protect principals by requiring that they can't sort of blunder into giving their agent a power that will allow them to give away all of the principal's assets or radically change the disposition of their assets unless they decide that that's something they want to do. So before Act 95, you only had to use a specific grant of authority to let your agent make gifts or to let your agent delegate authority for another person to act on their behalf. Now there are a whole bunch of things for which you must specifically designate that your agent has the power to do. That was fabulous grammar, sorry about that. So you can give your agent the power to create, amend, revoke, or terminate an inter vivos trust. For this to work for estate planning, you certainly have, your principal has to have already created a revocable trust, but that works. You have to give the agent power to make gifts, to create or change rights of survivorship, to create or change beneficiary designations. And under beneficiary designations, I note that the power under the statutory short form to handle retirement benefits no longer works. That doesn't capture changing beneficiary designation. So it really has to, and that's, again, sort of hearkening back to Vine, where perhaps if the husband had just drawn up a general power of attorney, and it didn't have the specific power, then the principal would have been protected, that he couldn't have gone in and made a pension election that was to her detriment. So the other things that must be specifically granted are to delegate authority granted under the power of attorney, as under the old law, to waive the principal's right to be a beneficiary of a joint and survivor annuity, including a survivor benefit under the retirement plan, to exercise fiduciary powers that the principal has the authority to delegate, and to disclaim property, including disclaimer of a power of appointment. So these all really go towards estate planning and arranging your property and rights therein. As I mentioned before, a general grant of authority to do all acts that a principal is authorized to perform will not grant these powers. And on a tax note, which cue collective groan from the crowd, 5601.4b provides that notwithstanding a grant of specific authority, the agent can't create an interest in favor of him or herself or an individual to whom he or she owes a legal obligation of support. And that's because you don't want to give them a general power of appointment over the principal's assets, which would cause those assets to be included in the agent's estate. So that's, assuming you're dealing with big enough numbers, you could cause the agent to have to pay tax on assets that aren't theirs. Okay, moving right along. So among these specifically delegated powers is the authority to make gifts. And prior law said that the agent could make, if you gave the agent a power to make limited gifts, that meant that the agent could make annual exclusion gifts, or if the principal was married, twice the amount of the annual exclusion, currently $14,000, to the spouse, the principal's children, and the spouses of the principal's children. So the idea being that if you're going to be making annual exclusion gifts as a way to spend down the principal's estate, that generally the object of the principal's bounty are his spouse and kids. Or they could, you could spend the money for the things that are exempt from gift tax, which are qualified tuition expenses and medical expenses. So you're not incurring gift tax, you're getting rid of the assets. This is sort of estate planning 101. Act 95 goes a little further. It says that unless the power, you must specifically delegate it, but unless the power otherwise provides, the power to make limited gifts is the power to make an annual exclusion gift, or again, double that amount if you're going to be doing gift splitting, to a person, any person. So this doesn't take into account sort of the natural objects of the principal's bounty. It's really anyone. That's sort of a terrifying power to give. It could be very liberating. You could tell your agent that, you want to give annual exclusion gifts to your best friend. But at the same time, they could also go off and give it to their bookie. So in practice, a lot of these things are not the same. We don't put in the same provisions as the statutory provisions let you. So this is a statutory presumption, and you can change it any way you want. So there's a later part of Act 95 that says that you can take the statutory short form language and then tailor it to your liking. So you could say the power to make limited gifts, I grant that, but only to my lineal descendants and the spouses of my lineal descendants, or something like that. But in our practice, it typically is that you give a much broader power to make gifts, that you don't have, you say that you can give gifts way above the annual exclusion amount. You can treat children and their family lines unequally. It's sort of the sky's the limit in terms of estate planning, but the trick is to advise your client that as to what they're actually doing, what they're giving up. It's more than the power for your agent to make an annual exclusion gift to his bookie. So it's sort of, there's some give and take there, and the power to make limited gifts has changed, but overall the issues are the same in terms of advising your clients about the power to make gifts in their power of attorney. Moving on, agents have these guidelines. They can make gifts only if gifts are consistent with the principal's objectives, if actually known by the agent, and if unknown, as the agent determines is consistent with the principal's best interest based on, and then this whole list of things. Essentially, what are their goals? How much money do they have? How much can they afford to give away? What is their feeling on how much tax they should pay and how badly they want to avoid taxes? And everybody's favorite, Medicaid planning. And finally, the principal's history in terms of making gifts. It would be a hard case to make if, the principal was never making annual exclusion gifts and always gave money to charity, and all of a sudden, $14,000 gifts are going out to every grandchild. It's not the worst thing in the world, but also it's not in line with what the principal did in the past. Other miscellaneous items, I alluded to this before, that Act 95 adds a section that permits the use of or actually requires the acceptance of a photocopy or an electronically transmitted copy of an original power of attorney, which should have the same effect as an original. And then there's an except for recording with the Orphans Court or the Office of Recording of Deeds. I don't know about you guys, but that makes me a little nervous. I was just fiddling around upstairs with a PDF document that, you know, just a regular Adobe on my computer lets us edit the text in a PDF with absolutely no problem. In terms of preventing misuse and abuse of powers of attorney, I just don't, that makes me a little nervous. But on the other hand, we live in a digital age, and Ben pointed out to me that there is a system at the Orphans Court and the Office for Recording Deeds that you can get a certified copy of an original power of attorney. So I wonder if there's some middle ground there, that if right now what we have is any old photocopy will do, which is certainly beneficial in terms of you're out in California, you need to execute one right away so that your spouse can transfer title to your car at the AAA. You can fax it over and you're done. You don't have to FedEx it back and forth. But on the other hand, it can be easily changed. So I wonder if there's going to be some kind of middle ground eventually where you can put it on file at the Orphans Court and then get as many certified copies as you need. That would take care of sort of the problem of not having enough originals. You know, if you only executed one or two originals and then they get destroyed and the principal's incapacitated, what do? You have to go get a guardianship, and nobody wants that. So a photocopy is useful in that sense, but again, not protective against fraud. So I think that for right now, we're kind of stuck with photocopies will work for whatever purpose you want them to work for, except for transfer of real property and recording at the Orphans Court. And maybe I'm just, the phrase that comes to mind is an old fuddy-duddy. I don't think that's in common usage anymore. But I mean, maybe I'm just being too conservative and I'm worried about nothing and this is all going to work fine, or maybe the Pennsylvania legislature will come back and make a change. And then just a few miscellaneous items. In terms of securities transactions, the power to engage in stock and bond transactions was always meant to, and that's a short form statutory power of attorney, meant you could join in any merger, reorganization, voting trust plan, or any other concerted action, and they've added in consolidation, dissolution, or merger into that definition. I don't know that those are necessarily excluded from the prior law, but now they are specifically included. Likewise, under insurance and annuity transactions, the power to engage in insurance transactions in the short form were transactions involving life, accident, health, disability, or liability insurance, and Act 95 adds in annuity transactions. Annuities are often sold by insurance companies, and so that's just sort of inserted in there. So if you have the power to make insurance transactions, that includes annuities. But then it also comes back, as we mentioned earlier, and said, and by the way, if you're dealing with annuities, you can't change the beneficiary designation unless you're given the specific power to do so. So that comes full circle there. On validity of non-Pennsylvania powers of attorney. Under the prior law, you presented a power of attorney executed in another state. It was considered valid as long as it was executed according to the laws of that state, except to the extent the power would allow an agent to make a decision inconsistent with the laws of Pennsylvania, which sort of requires an in-depth analysis beyond what most, say, bank officers are willing to undertake, or perhaps ninth-year associates at Ballard Spahr, I'm not sure which. Act 95 says, essentially, that a power of attorney that's validly executed in another jurisdiction is valid in Pennsylvania. So it just disposes with, but would Pennsylvania approve of the powers? So that's helpful. And now, Ben is going to we're going to talk about applicability dates, and we're both looking at each other because these are really complicated. So, Ben, perhaps you could tear it down.
I do the short version or the long version? The short version is...
What time is it?
A lot of questions. The short version is this. Generally, revisions relating to execution, specific grants of authority, kind of things that will require changing of forms are effective on January 1st. The balance of the Act kind of the acceptance of and reliance upon the power of attorney, third-party liability, all those things are currently effective as of July 2nd, the date that the Act 95 was signed. And if you're in litigation about a power of attorney, see me afterwards, we can talk. The long version would be to go through each of these. So sections 9 and 10 of Act 95 together create the effective dates of each section. And certain provisions apply to powers created on or after July 2nd, 2004, retroactively apply to acts performed after December 15th, 1992, and to judicial proceedings commenced before July 2nd, 2014, and one would assume on or after that date as well. And that's the definition of good faith and Section 5608, which deals with acceptance of and reliance upon the power of attorney.
All right, show of hands. We really only planned for an hour, and I know the invitation says an hour and a half. We could take questions and wrap this up. Show of hands, yay. Or we can come up with some hypotheticals, and Ben can keep talking about applicability dates. So who's counting on an hour and a half? Come on. Okay, bring it on. Well, funny you should ask that. I asked that same question of our drafter extraordinaire, and she said, you can't change your notice yet because then it won't be valid under the current statute. So the 2014 statute says that your power of attorney isn't valid unless you have the old notice. And so if you change to the new notice, you won't be in compliance with the old statute, which doesn't become effective until January 1st. So essentially, we are getting everything ready, and for any powers of attorney for Pennsylvania residents drafted after January 1st, they will have the new notice language in them. Yeah, we puzzled through the same thing. A power of attorney executed up until January 1st will continue to be effective after January 1st if it was effective when executed. Yes, well, that's always a challenge. But you could get an opinion of counsel. So they could. No, the bank can ask for an opinion of counsel. Actually, I believe it's supposed to be at the principal's expense, which is kind of rough because it's the bank's protection at the principal's expense. It's led us to wonder whether we should prepare some sort of form certification that we can send out to our clients when banks ask for this, so it won't be expensive for them. Or I guess it depends on what kind of inquiry the bank makes. If it's a factual certification, then you're going to have to customize, and hopefully it doesn't cost them too much. Good question. It's not, so the duty is not, the notice is just to warn the principal, and it's to warn the agent in the acknowledgement. That duty exists whether or not it is in the text of the power. So I would say we probably are not covering it, and right, it's still in the statute. Katie. I would hope so, but I actually don't recall any specific comment on that. I think I have been frustrated with the same loophole myself, and I would hope that fixes it, but I don't know. Oh, questions from the webinar?
Lindsay, you.
No.
Does it require?
Wait, Benji's raising his hand. Is this your question? Okay. Yes, but I'm wondering if the webinar people can hear Benji's question. I'm going to look at Lisa, and she says no. Okay, so the question was, you can grant a power to amend a revocable trust, an inter vivos trust, but you may not grant, the principal may not grant a power to change his or her will. And the point where I'm sort of hesitating is that I believe that an agent can be given the power to create a trust for the principal's benefit. So perhaps that's the way off the fly paper, but that's very limited. I think it has to vest in the agent's estate yes, the principal's estate at the principal's death. So yes, the power to change an estate plan would appear to depend entirely on whether or not the principal has a revocable trust and a pour-over will. But I'd be happy to entertain opinions to the contrary. I don't think so, but unfortunately I wasn't on the committee. So the comment was that if Pennsylvania is, and correct me if I'm wrong here, but if Pennsylvania is recognizing out-of-state powers, if they were validly executed, out-of-state executions, if they're validly executed, and if other states have less stringent execution requirements, would it work, for lack of a better way to say it, for a principal to do an out-of-state execution and not have to go get a notary and, you know, have his agents see a notary to acknowledge their duties, et cetera, instead of following Pennsylvania's formalities? And I think you're right about that, Benji, but I think that it's also a lot of hoorah to avoid a notary. I suppose if you're, fair enough. All right, well, so who is this person who sent me a question directly? Because everybody else, please direct your questions to Ben.
Lindsay, does the requirement that an agent act in the best interest of the principal impair powers of attorney contained in loan documents authorizing the lender to do certain things in the interest of the lender?
Ben, do you know the answer to that?
requirement?
Most of these requirements don't apply to business powers of attorney. I don't know whether the duty to act in the best interest necessarily applies to a bank power of attorney, but I'm guessing not.
Yeah, that would be my answer as well. And then second part of the three-part question. As to the disclosure of transactions, can the requirement for such disclosure be built into the power of attorney when it is signed and thereby front-loading the responsibility to do so?
I don't see why not. You know, if a principal wants the agent to disclose every single transaction ever made to, let's say, his or her children, certainly they could require that. I think you might have trouble finding an agent who's willing to act under those circumstances, but maybe for a fee.
Right, certainly. So it's a waivable requirement, so I can't imagine that it can be modified to go the other way as well. I don't know, every year, every 6 months. I don't know what the answer is, but the third part of a three-part question, would the requirement for a specific grant of power to create a right of survivorship apply to the authority of an agent to create such a right in a deed from or to the principal?
I got to read that one. Requirement. Ben, you have any ideas?
Is that allowed again?
Sorry, that's a complicated one.
Would the requirement for a specific grant of power to create a right of survivorship apply to the authority of an agent to create such a right in a deed from or to the principal? I don't know.
Yeah, I mean, breaking it down, the requirement to create a right of survivorship, I mean, certainly a power of attorney is essentially a contract between the principal and the agent. Or I'm looking at Benji because he probably has a clarification there. But, and so I think you can require anything you want of your agent, but and yeah, I mean, I don't see why an agent couldn't create a right of survivorship by deed if it was in the best interest of the principal. I mean, I think that's the bottom line, is that the agent may do anything as long as there is a specific grant of the power with regard to creating joint and rights of survivorship and the like, as long as there's a specific grant of the power in the power of attorney. I hope that answers the question, but to the questioner, please feel free to email me.
I concur.
Or Ben.
Email Lindsay.
Katie. Thanks, Lisa.
Right, I think you're right. Yeah, that's another one of the changes to the limited gift definition that maybe doesn't change it for the better.
Yes. No, just acknowledged. Yes. Mm-hmm. Well, there's nothing about that in the statute. It sounds like the legislature could have used you on the committee. But I don't think it would be a bad idea in delegating to say that, you know, I'm delegating this and here are the rights and duties, and then have the agent sign an acceptance of delegation, which is pretty common practice, is to have them accept the delegation, and that way you would have a written record that they knew what their rights and their duties were. I don't know. I can guess. I'm going to guess. State employees retirement system had a dog in that horse in that race. Excuse me. Probably financial institutions. You want to. We answer questions from financial institutions all the time, and they typically begin, "Is this a valid power of attorney?" And I'm attaching a PDF, and so I would guess that those were the primary people trying to limit their liability, especially after Vine, because Pennsylvania State Employees Retirement System had to go back and adjust these payments retroactively for Teresa Vine, and then had to continue the stream of payments going forward, and that was not insignificant. Okay. I think it would be a great opportunity to work with financial institutions in advance of our clients needing to get their power of attorney accepted. So far, no financial institution has come to us and said, "Hey, what do you think of our form power of attorney and what our requirements are?" A lot of our efforts are either in identifying what's already been done and submitted to them when we represent the financial institution, or in trying to make our power of attorney, which of course is state of the art, fit into their, get them to accept that as operative. I think it's a great idea to try to work in advance, especially with some of the larger providers, and see if we can come up with something that works for everyone. Yes. Mm-hmm. Yeah. So you mentioned advanced directive. Are you talking only about healthcare decisions, or? Okay, just the financial power of attorney then. Mm-hmm. Well, I think that you can leave out a lot of the bells and whistles on power of attorney for someone with modest means. I don't think that they need to have the power to make gifts, to give their agent the power to make any gifts. They have very modest means. They're not going to try to spend down their estate to avoid federal estate tax. Likewise, they're probably not going to have a revocable trust or desire to change the disposition of their estate for tax purposes. So what you have is just a straightforward document that has to be witnessed by two people, notarized or acknowledged by a member of the bar of the Supreme Court of Pennsylvania, and then the agents have to acknowledge their duties. So I think that overall the complications aren't really for the clients with modest means. It's really for a more complicated estate. Yes. Agreed. So the comment was that perhaps the gifting power is important because of the possibility of the need for Medicaid planning. I agree with that. Benji, you were raising your hand. don't think I can summarize that quite as eloquently, but I thank you. All right, well, Tom. No, it's, well, Benji's raising his hand, so he may contradict me. Wait, hang on. If you're going to give an actual substantive answer, you've got to take the mic. I'm sorry. Here. Does this work out here? Oh, it does. Look at this.
The problem is for the lawyer who is asked to take the document out of the safe, and we've talked about this a good deal when this routine started, of telling clients, you can put it away and don't have to worry about it. We won't give it to anybody unless it's needed. And then somebody, 16 years later, I think was your time period, somebody who doesn't know anything about any of these people is asked to cough this thing up and be sure it's all okay. And it illustrates very effectively how different the world is now. Because when I started in this business, you knew all the people who would be likely to do that, and they gave out their powers of attorney. I mean, there are all kinds of little horribles in the background.
I might also add that in this day of PDFs and now the fact that a photocopy has to be accepted, that, you know, the time when you might have said, I'm going to hold this original in my vault and then send your client a photocopy, and that would guard against an agent making an unauthorized use of the power, because immediately when they sign it, it's effective. You can use it. The principal doesn't have to be incapacitated. And so we used to sort of safeguard against undesirable use by holding the originals in the vault. But now, with the photocopies floating around that are just as good as the originals, it remains to be seen whether you can protect against that kind of use. Can't was the verdict. How are we doing on time? I mistakenly did not wear a watch. Okay. All right, well, I vote that we do not sit and stare at each other for 12 minutes. So, oh, more questions. We have thought about that. We was talking a little earlier about perhaps coming up with some kind of on-demand opinion of counsel that this is a validly executed. Maybe you draft it as your client is executing the power of attorney, that on such and such day you met with them, they signed it, they had capacity, you knew this because X, Y, and Z, and therefore it's a validly executed power of attorney. Maybe you keep that in their file, and then you can produce it if needed. Although I'm sure there are other solutions to that. I agree, it's a difficult problem, but it's a difficult problem now with people wanting powers of attorney accepted right away, and then having to go through legal departments and perhaps out to outside counsel for evaluation and that sort of thing. Okay. Yeah. Mm-hmm. Well, the one perhaps silver lining is that the third parties are sort of granted blanket immunity almost when on the face of it the power is validly executed. And so you'd think. So as of July 2nd, they've had that immunity. I don't know when it was you were trying to get your power accepted, but that certainly is one more arrow in your quiver to say, look, it meets all the execution requirements and you have immunity for accepting this unless you have actual knowledge that something's wrong with it. And then perhaps ask them what their actual knowledge is and maybe you'll get somewhere. It's a tough thing.
No, I completely agree. I think that the law should promote acceptance at this point.
Are there any other questions? You guys have been a great question-asking crowd. I think you deserve your extra half an hour of CLE. Thank you all for coming. Please feel free to email Ben with any questions you might have.
I'm much better by email.